Well, good evening, folks. Welcome back to another session of Chattin on the Porch. My name is Brian Trippett. I am your front porch conservative. Thank you for your patience, and we're glad to have you guys here tonight. We are on YouTube, we are on Rumble, we are on Twitter. So if you haven't done it yet, send it out. Let people know you're here. Let people know you want to be heard. Let people know you want them to hear you and be heard and be seen. So invite your friends, tell them to stop on by, and let's get together and let's have a discussion. Again, we are on YouTube, Rumble, Twitter. Thank you for your Twitter tweets, getters, gets, gabs, truth socials, Facebook posts, whatever you've been doing to advertise it. We genuinely appreciate it. Glad to have you all here tonight for another session of Chatting on the Porch. And given everything that's been going on up in that crazy state of New York and all things legal, I thought it might be a good time to bring back a friend of the front porch. We've had him on a couple of times, and when it comes to matters legal, I like to get his perspective on things. And given what's been going on with Letitia James, Arthur Engeron, and now soon to be Alvin Bragg, this thing is about to bust loose. Now, you've known him from previous appearances, but if you're not familiar with who he is the author of Fake News Exposed about Trump. He is a lawyer from Louisiana and a good friend to this a wonderful little endeavor of a social media channel, and we bring you this good fellow here, Mr. Daniel R. Street. Daniel, welcome back to the Electronic Front Porch.
Thank you for having me. Glad to be here.
Oh, thank you for coming on. Like I said, with everything that's been busting loose up in New York State, I thought, I need some clarity here because there's a bunch of issues surrounding what's going on legally as it relates to Trump, and I thought, okay, it's time to get into the weeds on this, so to speak. So we're glad you're here. And as we see in the audience, the professor has arrived. Thank you, Christian Watson. Good to have you here. And Miss Leah, love you, dear. Glad you're here and looking as wonderful as always. Okay, let's start with this whole Arthur Engeron, Letitia James, $355 million, which wound up being $454 million plus change. There's a bunch of questions that I've got about this, and I'm trying to wrap my mind around this thing. And I start with the following premises. If Donald Trump is guilty, okay, fine. Then let him have it. Throw the book at him. He's no better than the dog catcher or anybody in between. I don't care if he's a former president of the United States. If he's guilty of something, he's guilty of something. But I am loath to understand what exactly he's guilty of. And again, I'm not trying to be naive, and I'm not trying to, stick up for Trump in this thing. I'm trying to be as objective as possible. Here's my problem with this case that Letitia James brought and that Arthur Engeron ruled. It's a case involving commercial matters. Okay, that's fine. You can commit crimes under commercial matters. I get that. But normally with a crime, there's a perpetrator and there's a victim. In this case, the supposed victims, the banks, the insurance companies, and supposedly, I guess, the people of New York State, nobody's claiming victimhood here, except for Letitia James. Can you elaborate to our audience exactly what was he charged with and what kind of law did they base this on? Because to me, this makes no sense, and I'll explain where I'm going when you get done with your answer.
Sure. Well, the claims brought were claims to recover civil fines for alleged violations of a New York State civil fine statute. Okay, the exact number of it is it's a really long, rambling. It's Executive Law Section 6312. It is one giant long sentence that's probably 300 or 400 words. And it just says that whenever any person engages in repeated fraudulent or illegal acts or otherwise demonstrates persistent fraud or illegality in carrying on business, that the government can do these things. The reason I'm looking over here is I was reading from the statute.
Sure, that's fine. That's fine. So
it's this old statute. It's been around a long time. It's written, for lack of a better word, kind of old, almost like old English language. It's just a big, long, rambling, long sentence. And that's what the New York Attorney General has brought this civil claim saying that President Trump, and it's not just President Trump, but mainly it's that the Trump Organization and various different Trump entities were inflating the value of various different properties and assets in order to secure credit facilities and to finance various different aspects of the business, and that they allegedly obtained some ill-gotten gains that, for the most part, were calculated through interest rates that were more favorable, allegedly more favorable to the Trump organization. So that's the basic fundamental thing. Really, all the government came in and says, "Oh, look, you took these properties, and whenever you were getting your credit and securing your credit facilities and getting your loans, you overvalued these properties and obtained more beneficial interest rates. And because of that, we're going to strip you of the profits that you obtained from the subsequent sale or from the operation of these properties." That is what is known as disgorgement in the law, which is reclaiming someone's profits. And the reason they had to use the disgorgement theory is because there were no victims to compensate.
Okay, now here's my question, and this is something that I think that I'd maybe mentioned when we were talking, off air about this, when I reached out to you. From what I understand, under normal circumstances, there's a statute of limitations on this sort of thing. In other words, from my understanding about this case, these loans were done, most of them, were done so long ago that even if Trump had done something untoward and or illegal, let's just go right to illegal, okay? If he'd done something illegal, the loans were so long ago, most of them, that under statute of limitations, you wouldn't be able to even bring a case on this. Is that true?
Yeah, well, what they did, what the government alleged, and what the New York Attorney General claimed was this was part of an ongoing pattern or practice or scheme.
Okay.
And to get around, with respect to at least 2 or 3 of the transactions, you're right, we're talking way beyond the statute of limitations, but they circumvented that by claiming that this was a scheme that was ongoing. It was there's all these acts in furtherance of it taking over a period of years, so it just really never ended, and the court bought that.
Okay, now here's where I'm having trouble with the argument made by some that Trump is, crooked like a dog's hind leg on this question. And here's where I'm coming from. I don't have commercial lending experience, but I've got retail lending experience in a previous life. If a man walks in and says, "I want to borrow $100,000 and I've got a house that's worth $150,000, I take his information, I run his application, I run his credit, I look at his statements of asset, which more often than not be his bank accounts, and then I order an appraiser to go out and value the property." Okay. Appraiser comes back and says, "Hey, Brian, your borrower, this house ain't worth $150,000. This thing's more like $100. But he's got good credit. He's got assets." I go to my manager. I'm like, "Look, guys want this. House isn't going to value for it. What do you want me to do here?" Manager says, "Oh, okay, look. He says he only needs X amount of money. Let's counteroffer here." So I go back and counteroffer. Borrower's got 2 choices. He can either walk or he can take the deal he's being offered. Now, let's fast forward this to Trump. In order for Letitia James's argument to be even remotely true, at least in my book, okay, the banks would have had to have been one of 2 things: stupid or complicit. And here's what I'm getting at. Either they're stupid in that Donald Trump walked into the bank and said, "Here's the value of my assets. I want a loan under these terms because, my net worth is blah, 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 blah." And the banks swallowed whole everything Donald Trump said, took him at his word, did no due diligence, and let him walk out the door with the money on the terms he wanted. Either they were stupid or they're complicit. If they're complicit, that means they knew Donald Trump deliberately overstated his assets and gave him the terms he wanted, which under federal lending regulations, that's called disparate treatment. And if Letitia James wasn't up their backsides about it, the feds would be. So, I mean, this is where I'm having trouble with this.
Mm-hmm.
I mean, yeah, you can make the general argument, well, no regular person in New York could get, a loan. Like, they can't do that if you're a regular person. You can't overstate your assets. Okay, that's true, but that also works from the assumption the banks are not going to do any measured due diligence here. I mean, am I crazy for thinking this? Because I mean, I don't see how the banks even said in the hearings, we had no problem with his financial statements. We'd do business with him again if we could do it. I mean,
Yeah. Right. Well, first of all, what you described in kind of layman's terms is what took place. Obviously, these were more sophisticated. These statements of financial condition that President Trump provided and that was provided on behalf of the Trump entities to all these various different lenders were much more sophisticated than one that you or I might provide to a lender.
Sure.
And then the lender, we're also talking about lenders with departments and divisions that deal with very, very complicated, very large transactions. So some of these transactions were in the hundreds of millions of dollars. And so, yeah, every one of these lenders, and this is covered in all the rulings and a lot, I've covered some of it in my Substack, but the lenders went through their own due diligence. They did their own valuation of the properties. They did their own valuation of assets and of liabilities, and reached their own conclusions about whether the loans needed to be made or not. And really, what really baffles me about the whole thing, although I gotta say I'm not baffled about it. This was just a cooked up bunch of BS to try to tag Trump. That's all this was about. I mean, there's no mystery about that. But what the idea that the Trump organization got a better interest rate because of their statements of financial condition and their asset valuations is really just silly. And if you look at the actual facts of what happened, Trump got better interest rates because he provided recourse. He personally guaranteed these loans, and they were recourse loans instead of non-recourse loans. And he got better interest rates, and it's all reported and it's covered in the decisions. And where the lenders came in and said, we'd offer this interest rate unless you give us a personal guarantee. And he'd give them the personal guarantee to get the better interest rate. Now, that's a tremendous amount of individual exposure for President Trump. At the time, wasn't president, well, except right, with respect to the old post office in Washington, D.C. So really look, none of this really makes any sense. And there were no losses by anybody. All of the lenders got paid back. They got paid back on time, and they all made money and came to court and said, we do business with the Trump organization first chance we get. So it's really just, in my view, it's unprecedented. And certainly the penalties and the fines are unprecedented. And, I mentioned the old courthouse, the old post office in Washington is a perfect illustration. Do we have time for me to delve into that?
Yeah, go ahead. Go ahead.
Perfect illustration of how brilliant Donald Trump is and the people running his organization. They took that old post office. It was dilapidated. Nobody wanted it. Nobody would do anything with it. The GSA, which is the General Services Administration, is a branch of the Department of the federal government, had it. Couldn't do anything with it. Trump came in and got a 60-year lease agreement. So he doesn't even own the property, got the financing to refurbish the property. That's what the credit facilities were for. And that's what the complaints that the New York Attorney General and the New York court seized on to say, oh, you overvalued the assets and whatnot. And some of the collateral, they're claiming they overvalued the collateral. And but what President Trump did is he got the loan, refurbished the place, operated it as a hotel, ran it for about 10 years, sold it to the Waldorf, the company that runs the Waldorf Astoria, made $126 million. That was in 2022. The Waldorf Astoria company's already ran it in the ground and filed bankruptcy on it. So you see, President Trump had it for a decade, and he didn't make a lot of money with it, but made enough to sell it for $375 million to make $126 million profit.
Yep.
So just to me, it just illustrates how brilliant the man is, because the people running the Waldorf Astoria are not idiots. And they took it over and lost everything they put in it in a year and a half.
Yeah, absolutely extraordinary. So Engeron rules on this thing. hands down, one of the most massive penalties I've ever heard of, regardless of what profession you're in. Was it 454 million plus interest of like 126,000 a day, to the point Trump's got to go out, find somebody to give him a bond just to appeal the thing. And then finally the New York Appellate Court, and I do want to ask you about this. The New York Appellate Court gave Trump a slight bit of relief, which saying $175 million is slight relief is kind of crazy. But then again, compared to having to put up a bond of $454 million, yeah, it's relief. But in their ruling saying, hey, we're not suspending the judgment, but we are going to lower the bond, they gave no justification. Is that, I mean, and granted, you're doing cases in Louisiana, and I'm not saying that's not important, but it's not like, I say that, it's not like you're following New York legal system all the time. Is it unusual for an appellate court to just give no justification for why they're doing, say, here's what you're going to do. We've ruled, see ya. I mean,
honestly, I wouldn't have expected much from the Court of Appeal on the merits of why they did what they did. But let me back up. What we're talking about is an appeal that suspends the judgment. Okay. So keep in mind, President Trump and all the other defendants, all the Trump organizations, and Eric Trump and Donald Trump Jr., they could all appeal without posting a bond or without putting up the cash. They just couldn't stop the Attorney General from enforcing the judgment in the meantime.
So the bond stops her from being able to collect the $454 million.
That's right.
Okay.
Now, in Louisiana, we call it a suspensive appeal because it suspends the judgment. In most common law states, like New York, they call what you do is you seek a stay of execution. And there's a specific statute, which I was pulling up here while we were talking about it.
Sure.
Yeah. So there's two ways to do it. Essentially, you can put the cash up, deposit $454 million. The actual judgment is $365, and the legal interest ran it to $454.
Okay.
And you could put up the $454 million deposit in the registry of the court and say, I'm taking an appeal, or you can post a bond. Most people, when they appeal a judgment like that, post a bond, because ordinarily when you purchase an appeal bond, you pay a percentage, a small single-digit percentage of the face value of the bond. So if we were looking here at a $450 million bond, let's say, to make the math simple, the premium for that bond is going to be somewhere between 4 and 10%. A bond this big is probably going to be on the higher end. So it's going to cost you $30 or $40 million to take that appeal if you can buy the bond.
Okay.
Right, as opposed to coming up with $450 million to deposit in the registry of the court. That's what all that stuff was about the bond. So President Trump asked for the district court to allow him to appeal without posting a bond, or to post a lesser bond, and to suspend the effect of the judgment so that the judgment couldn't be executed in the meantime. The district judge, Judge Erdogan, denied all of that. And it was the Court of Appeal that has a series of protocols in place where a party can go say, hey, this is an unfair bond. Will you lower it for me or relieve me of the obligation of posting it? And the Court of Appeal said, hey, you can post a $175 million bond. And so that's what happened. But what is telling, even though the Court of Appeal did not give us any real explication of why they did what they did, they didn't just lower the bond. They went way beyond that. They suspended almost everything. They suspended the order permanently barring several different people from financial control of a New York corporation. They suspended barring President Trump from serving as an officer or director of a New York corporation for 3 years. They suspended barring Donald J. Trump and corporate defendants from applying for loans in New York for 3 years, and from barring Donald Trump Jr. and Eric Trump for serving as officers or directors in a New York corporation. So what they did was they say, we're suspending all of that also. Mm-hmm. So I have to tell you, if you're a court watcher and you look at that, I mean, that's a big hill that the court's saying, look, we're not going to allow that to be in place until we look at it. And that's a good indicator that the Court of Appeal is going to take a very, very critical view of this.
Very good.
I'm reading tea leaves there, but this is the Court of Appeal going to say we're stopping. The only thing they didn't suspend was the independent monitoring. That's it. Everything else the Court of Appeal suspended until the appeal is done. So that's a devastating blow to the Attorney General's plans.
I agree completely. And before we switch topics to other things legal and Trump related, a couple of questions from the audience from our good friend Christian Watson. Where does Daniel believe lawfare comes from? What school of thought in American law produced the foundation for lawfare? And he's got a follow-up question to that. Does he believe our legal system will ever become more rooted in natural law over common law? And I'll let you address both of those.
Okay, well, first of all, it's really easy where the lawfare came from. This has been in the works for decades, really. And I don't want to say it's just limited to leftists, but for the most part, it's leftist, where they take any provision of law they can and they stretch it as far as they can and attack anybody they can with it. And I could give you a host of illustrations of that. So it just developed over time from what I consider to be, in most cases, an abuse of the law.
Sure.
And it's combined with the ability of parties to judge shop, to get their pet case in front of a pet judge. Now, that's a whole nother topic that we could talk about for a long time.
Sure.
There's a bunch of ways to go about that and a bunch of ways to manipulate that and influence that. But what you have are people who are using the law, they're stretching it, they're taking it far beyond what it's intended to be or what it was intended to do. And then they get in front of a favorable judge and a lot of times manipulate their way to get in front of a favorable judge. And they get a judge that'll stretch the law also. And you wind up with what we have, which is people being sued left and right all over the country for things that using statutes that weren't originally intended to cover the things they're being used to cover now. And there's some wonderful, very recent illustrations of that. I've wrote about that on my Substack a number of times. There's the Voting Rights Act. I just wrote an article about how the Voting Rights Act was used to attack voter integrity efforts.
Yep.
And claiming that intimidation and coercion was, the Voting Rights Act, for instance, illegalizes coercing and intimidating voters, but that has historically been like something like the Klan or somebody who's threatening voters with violence. And now they've stretched it to using state law procedures for election integrity purposes. And the left took those and got a couple of courts to stretch intimidation and coercion to mean using state law procedures. So that's a good illustration of lawfare.
Mm-hmm. And do you think there will ever come a day when our legal system will get more rooted in natural law again versus common law, which is what we have now? Or do you think the tradition of common law is so ingrained in the American system, it'll never be either infused or replaced with more of a natural law system?
Well, natural law has a very specific meaning, and I don't know if the person asking the question had the same meaning that we give natural law and the law. And then I'm from Louisiana, and my legal education's in Louisiana, and I practice law in Louisiana, and we have a definition of natural law that differs from the common law definition of natural law. But what I will say about this is natural law in the traditional sense was originally the basis for law. Okay. And it's, really just emanates from the notion that conscientious beings know right from wrong. And over time, rules developed that were just right from wrong. And we recognize in our law, a good for instance of that is if I owe you some money, and under Louisiana law, if I owe you some money and the time for you to sue me and make me pay the money I owe runs, I still owe you under our law a natural obligation.
Exactly.
That obligation can never be eviscerated. I owed you the money. It was your money, and I owe it to you. So if I ever take a step in furtherance of that, I can never reclaim it. So if I say, well, I owed you $5,000, but here's $1,000, and then I come back and say, oh, well, the time around, I want my $1,000 back. Our courts say, no, you can't get your $1,000 back because you had a non-natural obligation. That's based off natural law. Okay. That's dead and gone, and it's never coming back. All right. I hate to say that because sometimes it's visceral and what you would think, hey, this is how this ought to work. But we're way beyond that. And of course, in Louisiana, we deal with a French civilian tradition as opposed to common law. But really what we're dealing with now is just more than anything is statutory law and then constitutional law.
Sure.
And of course, there's still common law and there's still common law rules, just like there's still civilian law rules. But the idea of going back to natural law is it's just impossible, in my opinion.
Fair enough. And if you're just joining us, my name is Brian Trippett. I'm the Front Porch Conservative. We're joined by attorney and author Daniel R. Street, talking about some of the cases against Donald Trump and some of the bases of these decisions, or not so much bases. And before we switch to our next topic, a couple other comments from chat. English common law is where most laws come from, says Next Pharaoh, like Castle Doctrine.
That's true.
Your point about the Court of Appeals taking that big of a bite out, small time republic, is like, yeah, absolutely true. Absolutely true. And Christian responds to your comments, 100% correct about natural law view of obligation. All right, let's shift gears if we may. And by the way, if you're watching this right now and you're not a subscriber to my channel, please give me a sub. I genuinely appreciate it. Please follow Daniel on Substack. He has got a regular column that comes out on a pretty good basis and very interesting stuff to read. So give him a follow on Substack. I've got channels on YouTube and Rumble. Give me some subs there. All right, let's get into Alvin Bragg, or as I love to refer to him, Alvin the New York Chipmunk. Yeah, you can use that one. Just give me credit on it. That's all I asked, dude.
Okay, I will.
Alvin the New York Chipmunk. So Alvin's got a case against Trump. And I tell you what, Donald Trump has had more stuff legally brought against him over the course of 77 years than I can even shake a stick at. But this one's got to be the most unusual I've ever heard of. And basically, and straighten me out where I'm wrong on this, but as I understand it, Bragg is making the argument that the payment that Trump's then attorney, Michael Cohen, made to Stormy Daniels as part of a non-disclosure agreement, a nuisance settlement, for lack of a better way of saying it, or at least that's the term I've heard, is somehow a violation of federal campaign finance law, such that he ought to be charged up on this thing. Now, the funny part about it, and again, I hope I'm not stealing your thunder here, the FEC wouldn't take up this case. The Attorney General of New York didn't take up this case. The prosecutor for the Southern District of New York, which is probably the most corrupt, well, I shouldn't use the word corrupt. Let's just put it this way.
I'm not going to argue with you.
They're generous in their willingness to go after certain cases. Let's put it that way. They wouldn't even touch this thing. This happened now almost 8 years ago, and there's got to be am I wrong to think that Alvin is just in need of something to do and he can't find anything better in New York City than to go after this case? Tell me what this thing's all about.
Well, it is as I characterize it, I'll do so politely on the air, is a steaming pile of dung of a case.
Okay.
That's a legal opinion. So it's a terrible case. All right.
Steaming pile of dung. Write that down, folks. That's the technical legal term for it.
Go on Westlaw and search for steaming pile of dung cases. All right. Here's what happened. Let's. Do you want me to, Brian? You want me to just describe the basics?
Yeah. You do this however you feel you need to do it.
Okay. And I wrote about this on my Substack almost a year ago. So if anybody wants to look that up,
here it is, folks.
The long, painful story short as possible as I can make it. Michael Cohen paid Stormy Daniels $130,000 to buy her story. So she was through Michael Avenatti, if you remember, the creepy porn lawyer who's doing more time in federal prison than I can count right now. She was shopping this story. And President Trump knew there were some people shopping stories. Now, there were 3 stories that are at issue in this in this indictment. two of them are proven to be untrue. So they were literally shakedowns of President Trump. None of those people are being charged with blackmail. They're trying to charge Trump with paying the claims. But all right. So what happened was there's President Trump is friends with the guy whose name escapes me that owns the National
Enquirer. I know. I can't think of his name either, but I know who you're talking
about. The National Enquirer got approached with a couple of these stories, and this guy goes and gets with Trump, and he gets with Michael Cohen and said, "We need to figure out. We got to do something about this." And so President Trump says, "Y'all take care of it." And I'm just paraphrasing. And what happens was the National Enquirer guy paid for a couple of these stories, and Cohen paid for one of the stories. Now, the biggest payment was made by Cohen. It was $130,000. One of them, a former doorman, was paid $30,000. If I think he's the guy who claimed that Trump had a love child with somebody. It was totally made up. And the other woman, I can't remember what she was paid. I want to say $26,000, but I might be wrong. Okay. But at any rate, the practice is called catch and kill. So there's nothing illegal about it, and that is buying someone's story for purposes of killing the story, burying the story, stopping the story from being published. So Michael Cohen forms a little LLC. He puts the money in the LLC. He goes and negotiates this deal for $130,000, negotiates a non-disclosure agreement so that Stormy Daniels, Stephanie Clifford's her real name, could never talk about the details with anybody, and pays the money. Later on, after the election, he comes up and wants his money back and says, "Hey, can you pay me back on this deal?" And President Trump came to this agreement about paying him back.
Okay.
All right. The alleged crime. There's two basic alleged crimes here. One is a falsifying documents crime, and the other is a falsifying documents crime. They're both crimes under New York law, allegedly, and basically it's falsifying business records. So what the DA claims is it was put on the books. These payments made to Cohen were put on the books as a monthly retainer. And there was a monthly figure that was paid to Michael Cohen. And the books say it's a retainer. And it wasn't a retainer. It was reimbursement for this payment made to Stormy Daniels. And since ultimately President Trump paid the man $400,000, there's obviously a big attorney fee in there. Okay. And so they're saying, well, it's marked down like it's payment for legal services. Some of them said retainer. Some of it said legal services. They said that's wrong. That's a mischaracterization. That's an illegal falsified business record. But that's only a misdemeanor. Okay. You only get to a felony if it's done to further or conceal another crime. And that's where we get to the campaign finance violation that you were referring to earlier. All right. So the Alvin Bragg claim is that this payment was really a campaign contribution by Michael Cohen, and that the false business entries were made to cloak it and conceal it so it wasn't reported. That's basically it. And the problem with that is the FEC, there was a complaint filed with the Federal Elections Commission over this exact issue, and they dismissed it. And I covered that in my Substack, and I linked to the articles, including from two former FEC commissioners that said this is not a campaign finance violation. And the federal government they indicted Michael Cohen for all sorts of things, but they didn't indict him for an illegal campaign contribution, and they didn't indict anybody else for conspiring to make an illegal campaign contribution. And the U.S. district, the district attorney for the Southern District of New York, which has territorial jurisdiction over this area of New York, that's the office formerly held by Rudy Giuliani back in the 80s, was held by a very anti-Trump zealot named Feet Barra back whenever this was going on. And he would have done anything he could to indict Trump and didn't even try. All right. So these state court these district court people, this Manhattan DA, this is the equivalent of wherever you live. It's the equivalent of your local DA charging Joe Biden for something. I mean, it's just ridiculous to start with. And it's him saying that, oh, this is a violation of federal law. And the reason they need to do that is to get them to a felony. All right. Because it's called falsification of business records in the second degree, and it's a felony if it's done in order to conceal an underlying crime. Okay. So the DA's office has to prove the underlying crime, and they have to prove the falsification of business records. And I outline in my Substack, there's a host of reasons why this case should have never seen the light of day. It's certainly not go to trial.
Yeah, I was thumbing through that Substack article, and if folks are looking for it on your Substack, let me find the exact date. It's May 21st of 2023 is when Daniel wrote this, and I tell you what, having read it now, having my memory refreshed on this, if you're wanting a really good primer on Alvin Bragg's case and why it is in legal terms a steaming pile of dung, this is probably as good an article as you're going to get. Matter of fact, I'll do everybody a favor right now. I'll save everybody some trouble. Let me pop this in comment, and if y'all want to link to it, you can. So I just dropped it in chat on the YouTube side, so check it out. And yeah, it's a fantastic article. But I think I managed to find in my quick little research, I think I found the FEC's response to this, and I want to show everybody one paragraph. And to me, this is amazing. It says, thus, we concluded that pursuing these matters further was not the best use of agency resources. Commission regularly dismisses matters where other government agencies have been adequately enforced and vindicated the commission's interest. Furthermore, by the time the commission was facing extensive enforcement docket, yada, 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 they said, look, it's a waste of our time. We're not even bothering with this.
That's right.
Okay, so just to restate this, it's not even, we don't even know if the story about Trump and Stormy Daniels is true. Okay.
That's correct.
All right. Number one. Number two, all Cohen was doing was literally buying the story. As you said, the term for it is capture and kill.
Catch and kill.
Catch and kill. So he's buying the story. She signs an NDA. He pays the money to Stormy Daniels out of his own pocket. Goes back to the Trump organization and says, hey, here's a bill for $400,000, for reimbursement and this. Trump's people recorded as one thing, and Bragg is saying, hey, you recorded it wrong, and it's a misdemeanor, which, as far as I know, the Trump organization is not denying, like, okay, fine. We made a mistake on how we reported. Am I stating everything accurately so far?
Yeah, with the exception that Cohen didn't bill him $400,000. At the end, President Trump paid him a bunch of extra money because he said, you're going to get hit so hard in taxes. We're going to give you another, I forget what it was, another extra $100,000 for taking care of all this,
Okay.
So, and the notations, these are accounting notations. These are just little notes in a book. Now, a couple of the payments President Trump made personally, I believe.
Okay.
The rest were made by the Trump organization. So then the question there is, did President Trump even have anything to do with how they marked them down in the Trump organization's books?
Yeah, I mean, he would basically, to believe Alvin Bragg, and again, stop me if I'm misunderstanding this, Bragg would basically have to show that Trump walked into the accountant's office and said, hey, mark it down this way. Now, let's get to the FEC side of this. So Bragg's basic argument is, hey, you knew what you were doing. You were trying to lift the corner of the rug, sweep this thing under it, drop the corner down, and you walk off. You knew what you were doing. So your organization did this, which led to this, and now we got a campaign finance violation. Is this stating it accurately?
That's basically it.
Okay. That is I mean, I've seen people stretch blankets out, but man, this one, if he does this, he's got a flying carpet on his hands.
Well, who in the hell is this guy to even opine what a campaign finance violation is? And let me tell you, Another thing that's important about this indictment, the indictment did not disclose what the underlying crime was, which is another reason why it should have been dismissed, by the way. That's been discerned from the motion practice.
Wait. Hold on. You mean he's not even telling the court at this point in filings, okay, here's what law he violated and here's why I believe he did?
That's correct. In the original indictment, what they alleged was that there's a false business record that's a violation of the false business record statute in the first degree, but that it was done to conceal another crime in the second degree. They did not identify the crime. And at the press conference, I actually have another Substack I wrote about his press conference because it was so prejudicial and unethical. And here I'm talking about Alvin Bragg's press conference. When he was asked, hey, what's the underlying crime that they were supposedly concealing? And he refused to answer that. Now, a criminal defendant's entitled to know what they're charged with having done wrong. This is a very, very basic fundamental rule of indictments.
Because he's got to be able to defend himself. He's got to know what crime he's accused of.
And in New York, and I cited all of this, if the indictment fails to adequately state the crimes committed by the defendant and the underlying misconduct of the defendant, they can't amend it to fix it. It's just unconstitutional. It gets thrown out. So it should have been thrown out for that reason. It should have been thrown out because the statute of limitations had run on most of it, under any, even the broadest interpretation. Look, all of this happened well, let me rephrase that. The payment was in 2016. The reimbursement that the alleged false business record notations, all of that happened in 2017. They didn't indict President Trump until 2023. That's 7 years, between 6 and 7 years later. So it's all unconstitutional. I mean, it's all prescribed. We call it. It's timed out.
Sure.
And I covered all that in my Substack. Now, some of it, if the felony charges were to stick, some of it would survive because of the COVID suspensions, and I cover that in my Substack. The time limits, including for criminal cases, were suspended by the governor, who was then Andrew Cuomo, for several months in 2020 because of the COVID pandemic. Mm-hmm. So that would have probably saved a few of the counts. There's 34 counts. It would have saved maybe 10. Okay. But the other issue is it's unconstitutional. It's an unconstitutional deprivation of due process rights of a criminal defendant in New York State. So this is a New York State constitutional rule to unduly delay prosecuting somebody. And in this case, they didn't indict President Trump for 6 years, literally for 6 years. And get a load of this. The original DA refused to bring the charges. Two of the district attorneys that were working on it resigned in
protest,
dispute and protest of the failure to charge him. One of them wrote a book about it. And he even talks about it. I cited in my Substack. He talks about this prosecutor says, this is really probably blackmail, but here's how we could turn that around on Trump, but here's the thing. They still didn't indict President Trump for over a year after the book came out. And I cited the cases where if they hold up for that created a presumption that the criminal defendant's due process rights have been violated if they wait more than a year to indict somebody. And I cited the cases. So why this case wasn't dismissed? There has to be a good faith excuse or justification for failing to indict. What could it possibly be when you've got two prosecutors who resigned in protest a year and a half before the indictment came out? Mm-hmm. And what most people don't know is what really got all this going was a longtime Democrat from the U.S. Department of Justice that was put in by the Biden administration was sent to Alvin Bragg's office in 2020. That's right. To coordinate all this, essentially, or that's what the reports are. But so the DOJ, the Biden regime, came in and orchestrated all this in all likelihood.
Jeez. Well, now I've got a question from the audience. I want to put this up here. Next Pharaoh asks, could Trump go after Stormy Daniels for violation of the NDA, forcing her to return the money? or has she even violated the NDA? Because I understand she's the judge is going to allow Marshawn, the judge overseeing this case, is going to allow Stormy Daniels to testify. Could
Yeah.
she be in violation of the NDA at that point? And if she does, can Trump go after her for to get the money back?
Ultimately, I don't believe President Trump signed the non-disclosure agreement. So
Okay.
I don't think the NDA ever actually became enforceable. And one other point about these business record notations and things is this.
Okay.
Michael Cohen did provide legal services. Negotiating the settlement's a legal service.
Okay.
Drafting the non-disclosure agreement's a legal service. Drafting the settlement agreement, which he did, those are all legal services. So the notations that said legal service, this was payment for legal services, those are correct. That's not even incorrect. Now the fact, and let me tell you, if a lawyer fronts costs, fronts expenses, which I've had done many, many times, that's still reimbursement for legal services. So some of these allegedly false notations aren't even false.
Jeez.
Yeah.
Unbelievable. Yeah, this case starts, what is it, April 15th? Ironically,
Yeah,
tax day of all days to start a case like this. Yeah, only in New York. Well, folks, with the remaining time we've got, let me do some real quick updates. My name is Brian Trippett on the Front Porch Conservative. We're joined by Louisiana attorney and author Daniel R. Street. We're talking about some of the legal goings on with Trump and New York State, and we're going to broaden it out just a little bit and talk about what's going on down in D.C. But if you haven't done it yet, do me a favor. If you're not subscribed to my channel, give me a sub on YouTube and Rumble. I would genuinely appreciate it. Daniel's got a Substack and is writing fabulous articles there. Please follow his work, support him wherever you can. All right, let's shift down to D.C. for a second. And just by way of preview, Daniel's going to be joining me and probably a host of other people on the 25th of April. We're going to be live streaming the oral arguments in the case of U.S. versus Trump. This is the presidential immunity case. And Daniel was able to check his schedule. He's able to join us. So we'll be doing that on a Thursday, 25th of April. Mark it on your calendars right now. So let's talk about the immunity case in the time we've got left. This, to me, is fascinating on so many levels. I think it was law tuber Nick Rekieta who made the comment that, I don't like talking about Trump so much, but daggone it, if the guy isn't making law that's interesting, who is these days? And not even really trying to. He's just trying to live his life and do his thing. But let's talk about the immunity case. Jack Smith's principal argument, at least in the D.C. circuit, is, hey, you were there on January 6th. You incited, you were inciting people to riot. You did all these things. You were delaying by your actions official proceedings of a meeting, which is a real stretch of federal law, by the way, which is also being argued at the Supreme Court as it relates to one of the J6 defendants. But we can get into that. What is this case against Trump? What is Trump's defense? Because he's claiming presidential immunity. For the sake of our audience, what's Jack Smith's argument? What's Trump's defense? And what should the law rule in this matter?
All right. So in the D.C. indictment, and I've actually written about this in my Substack as well, in the D.C. indictment, there are four fundamental charges. Well, there are four charges. Two of the charges are similar and two others are independent. So there's really three different violations alleged by Jack Smith. The first, they accuse President Trump in count one with violating 18 U.S.C. 371, which is conspiracy to defraud the United States. Now, that is a statute that's ordinarily used for tax cheats. Okay. Their argument here, which is hook and crook and novel.
That's the word I was just thinking, novel. It's very
it's novel. A novel argument. Oh, he was trying to defraud the United States out of an election, essentially. All right. It's crazy. And if we had a media with any integrity, this would have never seen the light of day. All right. Counts 2 and 3 charge President Trump with conspiracy to obstruct an official proceeding. That's the one you referenced.
Yeah.
Specifically. That's 18 U.S.C. 1512. And that's the case. That's the statute that's at the United States Supreme Court right now that we should get a ruling on probably in June.
Okay.
All right, that's the obstruction of official proceedings statute. But the problem they have, and it's not the first time I made this prognostication or this pronouncement, is that the U.S. Supreme Court's going to strike those counts from an unrelated indictment, but it's arising out of J6.
Sure.
So what happened on January 6th, one of the defendants, the Supreme Court's granted writ to decide whether or not the obstruction of official proceedings statute is applicable to the events of January 6th or not. And that will implicate the 2 charges against President Trump.
Sure.
The reason it doesn't apply is that statute was passed after the Enron scandal, when some of the principals to the Enron scandal allegedly interfered with a congressional investigation and told people to destroy evidence and things. And the litany in the statutory list of criminal acts, it's talking about a congressional investigation and says, if you tamper with evidence, destroy evidence, counsel somebody to destroy evidence, or otherwise obstruct an official proceeding. And the problem is, this wasn't a congressional investigation. And the statute's been on the books for 20 years. It's never been charged with anybody outside the context of tampering with evidence in a congressional investigation. Of course, none of that was done. And the statute doesn't apply. The Supreme Court's going to put an end to it, in my opinion. So that'll be 2 of the charges, the counts against President Trump, just wiped out. And the last one is conspiracy against rights. That's 18 U.S.C. 241. That's literally a statute that was used against the Ku Klux Klan. It actually says it prohibits 2 or more persons who conspire to injure, oppress, threaten, or intimidate any person in the free exercise or enjoyment of any right or privilege secured to him by the Constitution. The second sentence says it prohibits people from going in disguise on the highway for these purposes. It was used to prosecute the Klan. But what they're saying is that this was a conspiracy by President Trump to deprive people of their voting rights.
Okay, look. Okay, hold on. Ludicrous. I know that without his spray tan, Donald Trump is as white is very white. He ain't white as a Klan sheet. Okay, mm-hmm. That's just not happening.
No, and it's even worse than that, really, because there's a rule in federal constitutional law, that if an illegitimate vote, if a person casts an illegitimate vote, it dilutes the votes of other people and deprives other people who are valid voters and valid electors of some of their voting power. So if there's 5 legitimate voters and 1 illegitimate voter, that illegitimate voter implicates the other 5. So part of it is that rationale being applied to Trump's election challenges. It's cockamamie, horse pucky. All right. And it should have never, if our media was decent, just decent, they would be skewering these idiots for this lunacy instead of furthering and facilitating it.
Yeah, the part that just boggles the mind on this is it's not even just the charges. It's just the breakneck speed at which Jack Smith wants this trial started. I mean, it's like, okay, I found my charges. When can we get started? When can we go to court? When can we get started? When can we gavel this thing? And yeah. And half of this case, half of those 4 charges could get thrown out anywhere between now and June,
right?
Which means half the case is destroyed. And the other half of the case comes down to Trump's defense. And I wonder if you talk about this. He's arguing, hey, look, I got presidential immunity here. I should not be charged because I'm explain. I don't want to put words in your mouth. Explain his argument and why it may or may not even work here.
Okay. So there are 2 fundamental arguments that the president's legal team's making here. Okay. All right. And I'm going to simplify it, but those 2 arguments, the overwhelming majority of the argument is this, that President Trump was acting in connection with January 6th, in connection with the post, because they go beyond January 6th in the indictment. In the post-election efforts, that he was acting in his official capacity as president of the United States. All right. And it's specifically, they argue that he was acting within the outer perimeter of his official capacity as president. And because he was acting within his official capacity as president, that he's immune from any criminal liability, period. Okay. In the absence of impeachment. Okay. So he was impeached, but he was acquitted. Let me remind your viewers, and after January 6th, the Democrats controlled the United States House of Representatives at that time, and Nancy Pelosi rammed through an impeachment in a couple of weeks and impeached President Trump after he was out of office. And that impeachment was tried in the United States Senate, and President Trump was acquitted. And that impeachment included many of the charges in this indictment. Mm-hmm. So that's it in a nutshell. Now, the reason this is what we call res nova in the law, res nova means literally is Latin for new thing. The reason it's new is no president's ever been criminally charged for any conduct that occurred when he was in office in the history of this country. So there's no case law on it. Mm-hmm. And that's why it's a matter of such national import, and that the Supreme Court's going to weigh in on it. And, an important point to make, this issue was ruled on by the district court, ruled against President Trump. Then the D.C. Circuit ruled against President Trump. And let me observe, if this ruling from the D.C. Circuit had been an indictment of Barack Obama for ordering a drone strike that killed an American citizen in Yemen, all of that happened, the D.C. Circuit would have reached a different conclusion. They would have said there's presidential immunity, but instead you get these activist judges who won't give Trump the benefit that they would give anybody else. At any rate, they ruled against President Trump. President Trump actually filed a writ with the Supreme Court asking the Supreme Court to stay issuance of the mandate from the Court of Appeal so he could apply for en banc rehearing. Now, what all that means is when the Court of Appeal rules, they issue a mandate that says, this is what you have to do to the lower court. Ordinarily, that mandate wouldn't issue until after the time for applying for rehearing, and then after the court rules on rehearing. But the rehearings where you ask the Court of Appeal to take another look at it and say, okay, you ruled against me, but I think you're wrong. Would you look at it again? That's rehearing. This activist bunch on the D.C. Circuit issued an order, and they said the mandate's going to issue even if an application for rehearing is filed, but we'll stay it for 7 days to allow President Trump to apply to the Supreme Court. So he applied to the Supreme Court, asked the Supreme Court only to stay the mandate so that he could apply for en banc rehearing in the Court of Appeal. The United States Supreme Court converted that application to an application for writ of certiorari, granted it, and set the case for oral argument. So that tells you that the Supreme Court is anxious to weigh in on this question.
I'm not trying to read anything into what they did, but to me, it sounds like they've had enough. Well, now, how they're going to rule is a whole other issue, but it sounds to me like they've had enough. Like, all right, by God, we're gonna drop the hammer on this, and this is going to settle it.
Senators and congressmen have the immunity. Federal judges, federal judges have the immunity. Why wouldn't the president of the United States have the? Of course, they're going to rule that there's immunity for the president. Here's the other argument is the double jeopardy argument, because the United States Constitution says that with respect to impeachment, that a president is subject to prosecution if he's convicted on the impeachment article. The implication being, if he's not convicted, if he's acquitted on the impeachment articles, he's not subject to prosecution. That's the other issue, is the impeachment clause double jeopardy argument for the Supreme Court to rule on. But here's what I expect to happen. So let me shake up my crystal ball and look in it. All right. And I'm going to tell you something here that I did not come up with. There's some other commentators who are fantastic people. You should follow. William Shipley is one. He's the first one I saw mention this. Two things. But first, what I expect the court to rule on is this. What I expect them to rule is this. I expect them to say, yes, there's presidential immunity. The question is, were these alleged actions covered by official acts? Were these official acts of the presidency? And there's going to have to be some fact finding on that. And I expect them to remand it to the district court, tell the district court there's got to be a hearing about this, and they got to take some evidence about when these actions taken by the president were allegedly taken and where he was and what he was doing and who was advising and all that sort of thing. All right. That's what I expect to happen. But the second thing that's really important is that this issues before the court on what's called a motion to dismiss. And ordinarily, a motion to dismiss is considered in federal court on a motion to dismiss. The court considers the facts alleged in the indictment as true. All right. It's very, very critical that I don't think, and once again, I didn't come up with this. William Shipley and some others did, but I researched it and I think they're right. And that is that the United States Supreme Court, if you look at their writ grant, this is really critical. And I'm looking for it and I can't, technology is great until it doesn't work right.
Yeah, of course.
Well, it's working right as I'm not. Okay. Stay request Trump immunity. Let me see if this is it. No, that's not it. Anyway, the Supreme Court crafted the question because when they granted the writ and said oral argument, they said, we want the parties to address this question. And the question was phrased about, can a president be criminally indicted or criminally charged for his official acts? None of that language is found anywhere in the indictment. And the reason that's important is what I expect the Supreme Court to do is to throw out we believe the indictment for purposes of considering this, because the question they ask implicitly rejects the indictment.
Right.
And that's a critical question because there's no need for a fact finding if we just have to assume the indictment's true. Okay. So I know that's kind of in the weeds and it's an esoteric legal issue, but the lawyers looking at this like, whoa, that was a big tell from the Supreme Court about how they're approaching the question, and it's very, very favorable to President Trump's immunity claim.
Yeah, there's one. I mean, I'm no lawyer. I rely on the opinions of others in these matters, but there's one commonsensical thing that I don't think proponents of Jack Smith's position, the special prosecutor who's bringing this case against Trump in D.C., I don't think there's one thing they're considering, and you alluded to it a moment ago. Back early in the presidency of Barack Obama, he ordered a drone strike on an American citizen while the American citizen was on foreign soil. No due process.
That's right.
No trial, no nothing. He was you boil it all down, the American president had a citizen of the United States summarily executed by drone strike. Now, Obama would argue, hey, that was an official action of the presidency. It was for national security, yada, yada, yada. If the Supreme Court rules in Jack Smith's favor and says that presidential immunity doesn't cover you such that you could be sued after you leave office, the proponents of Jack Smith's position have opened the door. Why stop with Trump? Let's go after Obama. Let's go after Clinton. Let's go after, name the president. You've opened the door that anybody and everybody can go after them. So, when we hear this thing on the arguments on the 25th, this is going to be fascinating because this may be one of the biggest constitutional questions. And I'm not trying to hype this. I mean this sincerely. This might be one of the biggest constitutional questions that gets decided in a really long time. Because no one, it's like you said, no one's even thought about this in 200 plus years of American law.
Yeah, the reality is that what we're actually talking about is the ability to criminally prosecute a president after his administration.
Exactly.
So President Obama ordered a drone strike that killed an American citizen. Now, I'd have to go back and research it again as to whether the American citizen was the target. And knowingly, I don't remember off the top of my head, but none of that matters.
You're right.
Ultimately, as to whether you could be charged with a crime for it. And I found that language. The question the Supreme Court asked the parties to brief, whether and if so, to what extent does a former president enjoy presidential immunity for criminal prosecution for conduct alleged to involve official acts during his tenure in office? And the reason that's so critical is President Trump's the one who alleges it's official acts, not the special counsel.
Not special
I
counsel.
got to
Yeah.
see, what did I do with this article? This one may have been, I get articles published all the time. I
Sure.
can't remember where I published that one. Sorry. Yeah. I tell everybody, go to American Thinker, but I'm not sure if they're the one who published it or not. So,
well, for sure, we're going to be, you and I and a host of others will be watching, or I should say, listening to this, because they do not allow cameras in a federal courtroom. But we're going to do a special live stream on my channel Thursday, the 25th of April. Daniel's going to be there. I'm going to be there. A few others are going to be there. This is going to be probably one of those fascinating things we're going to get to hear. Daniel, as we wrap it up, where can people find you on social media? What can they do to support your efforts? Tell us about the books you've written. And like I say, just where can people plug into what you're doing and check out what you're saying?
Sure. All right. I tell everybody, go check out my website, danielrstreet.com. So that's danielrstreet.com. There's links to my Substack. And I always tell everybody, my Substack's free. Doesn't cost anybody anything. So I'd love to grow it and have more influence and be able to inform more people. So feel free to go sign up for it. You can sign up. You can follow me. There's links to my social media. I'm on Twitter, Daniel R. Street 1. I'm on True Social, Daniel R. Street. My books, and this is very important for your followers and your audience. My most recent book, which is the book that came out at the end of last year, that book is available free at my website. You can get the digital version, you get the PDF, you can get the Kindle, whatever you want, or you can get the audio. I even had an audio book done, and the narrator is fantastic. I mean, it sounds great. A lot of people like audio. I love audiobooks myself. You can get the audiobook or the digital version yourself for free at my website. So that's my most recent book. The book you have up right there is volume 3 of Fake News Exposed. I wrote a 3-volume series about misinformation and media propaganda and lies about President Trump, his administration, his family, and his supporters even. That's the first 3 books. Those are available at Amazon. They're in digital format or Kindle. They're paperback, hardback, and audio. So there's audio versions of all 3 of those books that are available at Amazon and at Audible. So, but you can link. There's links to them from my website. So just tell everybody, go to danielrstreet.com and you can follow everything I'm doing.
Okay, and I'm going to put that in chat right now. And the link to Daniel's website is there. I've also got it in the description on both YouTube and Rumble. Folks, like I say, we're going to be back here 25th of April on a Thursday. We don't know what time yet, but the court usually starts their oral arguments in the morning. So mark it on your calendars. We'll be back that day. In the meanwhile, I will be back this weekend with Front Porch Brunch, which is the weekly update on the news. And boy, have we got a lot to talk about this weekend. 2024 is definitely one heck of a year. I'll say that. So, folks, if you're not subscribed to my channels on YouTube and Rumble, I would greatly appreciate it. Follow me on Twitter at the Front Porch C1. There's a lot of good creators in here tonight. The Indian Jesus is in here. You've got my good buddy Christian Watson's in here. A bunch of other people. Please support their efforts as well. So, Daniel, hang on a second. We'll say some proper goodbyes, folks. Sure. Thank you for stopping by, and this has been a really fun evening. And have a good night. We'll catch you later. And if I don't talk to some of you between now and Sunday, have a happy Easter.